Welcome students. We are going to discuss Foreign Exchange Management Act 2000 part 2. This is in unit number 6 of your syllabus Business Regulatory Framework. You may recall in the previous program, that is FEMA 2000 part 1, we have understood the rationale behind introduction of Foreign Exchange Management Act. As was said earlier, that because of the economic policies of the government, because of the liberalization, privatization and globalization regime setting in the economy, it has become essential for the lawmakers to introduce a bill or introduce a act which will facilitate the foreign business as well as the movement of foreign exchange. In that program, we had talked about the extent of the FEMA Act, objectives of the Act and various definitions of different terminology used in the Act. Now, in this particular program, we are basically going to focus on the aspects of various provisions related to the regulation and management of foreign exchange. Namely, 6 provisions are there. Then we will also be talking about the aspects of the different authorities, the authorized persons appointed by the Reserve Bank of India, and then different appellate authorities, what is the organizational structure if a party has to lodge the appeal against any of the orders. So, first of all, we will be discussing the provisions of the Act. Now, provisions related to regulation and management of foreign exchange. As I have said, there are 6 provisions, namely provisions as to transaction in foreign exchange. This is highlighted in section 3 of the Act. Provisions as to holding of foreign exchange security by residents, section 4. As to current account transactions, very important one, section 5. Provisions as to capital account transactions, section 6. Provisions as to export of goods and services, section 7. And finally, provisions as to realization and repatriation of foreign exchange covered under section 8 of the Act. You will be appreciating the fact that it is these 6 provisions which form the core of the FEMA Act 2000. One by one, we will be understanding the interrelationship which is there among these provisions, and they go in this fashion that first of all, transactions in foreign exchange security will be discussed, followed by provisions as to who will be holding foreign exchange security, that will be covered. Then, like I have said, current account transactions, capital account transactions, then the provisions related to export of goods and services, and finally, the provisions regarding realization and repatriation of foreign exchange will be discussed. Now, first provisions which are covered under section 3 of the Act relate to the provisions regarding transactions in foreign exchange security. As per the Act, it is very clearly mentioned that no person, number 1, shall deal or transfer foreign exchange other than authorized person. For any transaction in foreign exchange, the Reserve Bank of India appoints the authorized person. How the authorized person is appointed and what are its responsibilities and roles, we will be discussing in the next part of the program. but this provision very clearly specifies that no person shall deal or transfer in foreign exchange other than authorized person. Number 2 is that no person shall make any payment to person resident outside. Number 3 is that no person will be allowed to receive any payment on behalf of any person resident in or outside India. Only the authorized person can receive payment by order on behalf of person resident in or outside India. And lastly, no person shall enter into any financial transaction in India to acquire any asset outside India. So, that means that these are the clear cut provisions regarding the transactions in foreign exchange security. As per the Act, only the authorized person is authorized to act as the agent who will be helping you out in the foreign exchange transactions. The interpretation of this provision is that there is a parallel trade which is called hawala trade, and the provisions of this Act effectively try to curb the malpractice of hawala, and so that the foreign exchange currency transactions are taking place only through the authorized person. Second provision covered under section 4 of the Act is regarding the provisions related to holding of foreign exchange. Who can hold foreign exchange? No person resident in India shall acquire or hold foreign exchange, foreign security, immovable property, that is of the foreign located in foreign locations. So, then we are actually trying to interpret here that regarding the foreign currency and foreign exchange, foreign security, it will not be held by any person other than the authorized person. There are some exceptions to this particular section 4, which are mentioned in section 9 of the Act, and only those exceptions are allowed to hold the foreign exchange or foreign security. Otherwise, in general, this provision will be applicable. Now, we come to the all important provision regarding provision as to current account transactions. Now, any person may sell or draw foreign exchange to or from an authorized person. The transaction has to be done through an authorized person if it is a current account transaction. But the central government and especially the Reserve Bank of India has the power to impose restrictions, and they do impose restrictions in the cases such as where speculation is involved. For example, if it is a foreign lottery, then that leads to or that encourages gambling, then that is not allowed as a current account transaction as per the provisions of this Act. This is one of the restriction imposed by the central government. Regarding the provisions as to current account transactions, this FAMA Act 2000 was amended on 20th April 2009, and the latest amendment has made it clear that some of the restrictions that were put on by the RBI have been relaxed as per the new amendment. Some of the restrictions are also there in the capital account transactions, which is the fourth provision of the FAMA Act 2000, and this is covering section 6 of the Act. Now, as per this provision, any person may sell or draw foreign exchange to or from an authorized person if it is a capital account transaction as per the restrictions or regulations by Reserve Bank of India. Transfer of foreign security by Indian resident, transfer of any security by Indian resident, transfer of any security by any branch, office or agency, and finally, any borrowing or lending of the foreign exchange will be permissible under this particular capital account transaction. That is where the main difference between current account and capital account transaction will be, where that the transactions are taking place with the intention of developing some physical capital, some asset which may have long term life. Then similarly, continuing further, this provision related to capital account transactions also cover any borrowing of lending, deposits between Indian and foreign residents, export, import, holding currency. That is one of the exceptions regarding the holding currency, transfer of immovable property in or outside India, giving guarantee of debt. Such provisions would be covered under the capital account transactions. As far as the next provision is concerned, this provision is regarding the export of goods and services. Many of the Indian business organizations may be engaged in exporting their products to any company located outside the country, and in certain cases some of the services are also exported, especially when we look at India. Our strength lies in the field of information technology. So, many IT enabled services are exported from India. Some of the BPO related business is also taking place, which will come under the export of service criteria. But here the provisions are clear that every exporter has to furnish declaration to the Reserve Bank of India regarding facts relating to exports. Now, this exporter not only has to do the declaration, but has to also furnish information asked by Reserve Bank of India from time to time. It will be the duty of exporter to furnish to Reserve Bank of India the declaration form. That means that it will be a self motivated exercise. The exporter has to arrange for the declaration form and furnish the information. RBI has the power to direct any exporter to furnish information or declaration, especially in cases where any particular default is found. Then we shift our attention to the sixth and last provisions, that is provisions as to realization and repatriation of foreign exchange. Any foreign exchange due to any resident Indian, now he will have to take steps to realize and repatriate to India such foreign exchange. Repatriation is not needed in the following cases: possession of foreign currency up to a specified limit by Reserve Bank of India, holding foreign currency account up to limit specified by Reserve Bank of India, foreign currency received before July 1947, special permission of RBI is required for that, foreign exchange by gift up to specified limits by Reserve Bank of India, foreign exchange acquired abroad up to limit specified by Reserve Bank of India, any other receipt specified by RBI. So, meaning thereby that the foreign currency that is received in the form of gift or in the form of other exchanges, other transfers, then the limits are specified by Reserve Bank of India, and up to that particular limit only one can hold the foreign exchange or foreign currency. And this is what I was telling you, that exception which is given in the section 9 of the Act here. After having discussed the 6 provisions of the Act, now we turn our attention to the next aspect of the Act FEMA 2000, that is authorized person. Because in the previous provisions it was discussed that the role of an authorized person is very important one when it comes to the transactions of foreign exchange currency. Then this is the procedure which is to be followed. It is only Reserve Bank of India in our country which is authorized to empower any person. RBI can authorize any person, but then that person has to actually apply to the Reserve Bank of India that he wants to be recognized as an authorized person, so that he can be dealing in the aspects such as the transactions of foreign exchange. Now, he has to use foreign exchange only for declared purpose, or else it will be treated as contravention. Now, meaning thereby that once he is authorized by Reserve Bank of India, then he has to fulfill the conditions, terms and conditions of the Reserve Bank of India. All the dealings that authorized person will be undertaking will be as per directions or orders of Reserve Bank of India. As far as the revocation is concerned, if it is found that the authorized person has contravened some of the rules or acts or provisions of FEMA, and if the Reserve Bank of India deems it in the public interest that the person fails to comply to the provisions of the Act, or he has contravened some of the rules, then Reserve Bank of India may think about or may take steps about revocation of the authorization that was given to the person. Now, it is the duty of the authorized person who has to submit in a timely manner declaration as well as information, and he has to also receive written and conditional authorization from Reserve Bank of India. Now, the Act goes on to discuss the aspects of if there are any disputes or if there are any problems, then what is the institutional mechanism for entertaining such kind of cases. And the Act FEMA Act 2000 has the provisions of the appointment of adjudicating authority. Now, this adjudicating authority is appointed by the central government. Any number of central government officers may be appointed as adjudicating authority, because less number of authorities will not be sufficient. The number of instances wherein such kind of adjudication has to be done may be large in number, as a result of which what happens is that the adjudication process may become tedious and slow. So, central government has to decide a specified number of the central government officers who can be appointed as adjudicating authority. Now, the functions of these adjudicating authority are to hold inquiry, and inquiry of especially the defaulters, and directing them to comply to the provisions of the FEMA Act. Their jurisdiction of the adjudicating authority will also be specified by the central government. Different officers may be given different jurisdiction, and then inquiry will be conducted only when any written complaint is received by them. And once a complaint is received, then the defaulter may have to appear personally or through legal practitioner. So, then personal appearance is up to the wish of the defaulter. He may go in for the use of legal practitioner to appear on his behalf before the adjudicating authority. the adjudicating authorities have similar powers as that of civil court, and so these adjudicating authorities have statutory status, statutory powers equivalent to that of a civil court. Once the adjudicating authorities have given their judgment, then if any of the party is not satisfied with that, then the FEMA Act 2000 makes further provision for the appointment of a special director, and appeal can be made to a special director. This is part 7 of the Act. Act makes appointment of a special director to hear the appeals against the adjudicating authorities, that if any complaint was lodged to the adjudicating authorities, they gave the defaulter an opportunity to either personally appear or appear through their legal practitioner, and then the decision of the adjudicating authority was given either favoring the complainant or exonerating the defaulter. So, either of the party, if they are not satisfied with the decision of the adjudicating authority, can approach agency higher body, that of a special director. Now, this special director, again there will be appointment of directors by central government. Again, like adjudicating officers, there will be not one, but many directors will be appointed by central government, and any person who is aggrieved by the judgment of the adjudicating authority has right to appeal, but period of appeal is 45 days from the passing of order by adjudicating authority. After 45 days are over, then that order of adjudicating authority cannot be challenged. Now, the order is given by special directors after hearing from both the parties, and the special directors have the power to set aside order if they deem fit. As far as sending copy of order is concerned, that copy of order also goes to appeal party, the one who has approached the special director, and a copy of the order is also sent to the adjudicating authority, so that they also have the knowledge as to whether the decision they have taken earlier in the same case, whether it was upheld by the higher body, that of special director, or it was set aside by the special director. Now, once again, like adjudicating authority, special director also has the powers same as that of civil court. Finally, there is the provision in the FEMA Act 2000 that we have the appellate tribunal for foreign exchange. Now, this appellate tribunal is also established by central government through this notification, and this is the highest level of appellate authority, in which we find that the judgments of both adjudicating authority as well as special directors are examined by this highest body of appellate tribunal. As I have said earlier, that this appellate tribunal is established by central government through the gazette notification. A chairman is appointed for this appellate tribunal, and this chairman then can have many members of the appellate tribunal. The chairman has to work along with the members to give judgment regarding the judgment of the lower level bodies. Again, same as the previous case, period of appeal is within period of 45 days. Order by the tribunal, after hearing, they can confirm, set aside, and third option is they can modify the order also, as the order is appealed against. In this program, we have talked about 6 provisions of the very important Foreign Exchange Management Act 2000. We have also discussed the procedure of appointment of an authorized person by Reserve Bank of India, what are the obligations of authorized person, that also was discussed, and then the mechanism for entertaining any complaint due to the contraventions of the FEMA Act, and 3-tier appeal mechanism, namely adjudicating authorities, special director and appellate tribunal, their constitution and responsibilities and powers were discussed. Thank you.